The burden contained therein is this, that you are increasing retail service and goods VAT from 3% to 15%. Simplicity.
7MTV.
Parliament ako asetna na sene enema bi ekeka kono. Ye be san tutu nneema mi. Ye be di bronya esi o monte nneema so ma ye finance minister kra be kan bi. Se woma wom ewo dwem no. Dwemfo mo hwe na motete nneema so no. Na so ndra wom kwa asetna nsema hodro wom keka no. Enema no afei ene ye betum. The valued added tax has been passed. Na ndra ena sa dwumede no ekoso ewo imrahye bedefie na yesi ye COVID tax free wa na mo sand bi ba be shema mai. Finance minister wan kan san kire yo. Obeka 2026 budget ne de 2 years sum se o ye be COVID ye ni agi se o ye be COVID tax free wa ma ye tete nneema so a mo de tax fufuro be shem na ese no mo dada yen.
The burden contained therein is this, that you are increasing retail service and goods VAT from 3% to 15%. Simplicity. 2, real estate is going up from 5 to 15%. This revenue neutrality language and all that, we're not interested. You are saying in your own report, you are saying that the introduction of this bill will help government to generate revenue. True or false? We are telling you that this bill is being brought because you need revenue. If you are not imposing tax, if this bill does not seek to burden the ordinary businessman, then what else are you seeking to achieve? If indeed you claim that there's revenue neutrality, etc., then let the status quo remain.
Na che se sene ekono NDC fo no mo ya daadan. Aban ya daadan. Musimu yi COVID free ho a mo de VAT ba be hye ho. Enema na ye be da atete so. Enema ye be den atete so. Ebusu amame ka o se tie bidwumede nam gusu a e de esom e wo 7MTV eso. Wo adwenkyera wo ho kwan se wo de to comment section, follow 7MTV Facebook, subscribe YouTube, betumi so a follow yen e wo TikTok. Pandai MP. Honorable Matthew Nyinam say ye twene sere ne abasa. Minority twino, majority so twene ama endra mpo no say na 9 say minority ye ya no won be press conference no enem dika gidigidi won be kasa ya won kire say papai ne ekobe nyina no won tai nechi enya ade a won be na ma da esan say yes ma won ra parliament o so wa woni say ya ma won 30 days for rerun election nti papai yes ma ni ra parliament na so NPP for na kira won tai nechi, and up to now he's saying he's still the MP, so to him no, he has the right to go to parliament. Majority so won mpene e ma ne mamra hye bedefie e na won mo twe papa sire ne abasa na onkope ne be ebintina no 23 days e won so say wa file for appeal enti nya botere na twen na appeal cry no cry say wa ko file there, because we just have 30 days da be na court bet na say aka sa asem ewie na won be kan na 30 days na enso ye ma rerun election na emba so ebedru na so. And I think say Papa, he has the right to be in parliament because Senator Oka said he's still the MP. No, he's still the MP. Enti mesremo mon shana Papa on the jumedie as the emrashe bedeni edema pandai abato empesweso and this for munya botre emra ewo ho no ma ye de bibia mo amunim na ekobe nyina say woma pandai empesweso ne ya womu hia bibia ama wom MP abegine ma ama wom na wom kofre ho anye papa ya na wom be frɛ no enti mo ka say when one 29 ANC why you are being too harsh, and this is what the minority had to say about whatever is going on. Now Roxin Nelson the Fiamekpo MP for South Dai papa me mom de me so say obetumi ayesa ne nsema na okeka e de fa MP for Pandai ho no it was too much. I don't know what Sembiana. This is what went on in Parliament yesterday.
Mr. Speaker, yesterday, 24th of November, 2025, the High Court of Tamale, has ordered that the outcome of the election, please, these are very serious matters, that the outcome of the 7th of December election 2024, which brought the Honorable Nyindam to this house as the Honorable Member for Kwanda, was flawed, and therefore that election has been ordered to be rerun. Mr. Speaker, ipso facto, the Honorable Nyindam is no longer a member of this house. It's not. So hear me, and so that you can respond. So, by operation of law, is no longer a member of this house with a voice. That's number one. Number two, Mr. Speaker, we have received the court orders and received proof of service. The orders of the court has been duly served on Parliament. It was served yesterday. Speaker, Speaker, it will serve the minority to listen to me in silence. If they are minded to respond, then they can respond.
Honourable members, please, let's listen to him.
We do it beautifully. So listen.
Let's listen to him, please.
Speaker, I have a copy of the proof of service of the orders of the Tamale High Court dated yesterday, 24th of November, and served on Parliament. The orders of the court was served by the court bailiff of the High Court Accra. It's called Solomon Osafu, bailiff of the High Court Accra. And I have the affidavit of service. So, Mr. Speaker, I will make all this available to the table office. Speaker, by operation of law, the Honorable Nyindam can no longer participate in our proceedings. If he's minded to appeal the decision of the High Court, it is right, and he has done so. But it is right that mere filing of an appeal does not operate as a stay of execution of the court orders. Mr. Speaker, further, a mere filing of a stay of execution. Please, there are two processes involved here. I've seen both copies. He has filed a notice of appeal. It does not operate as a stay against the execution of the orders of the High Court, Tamale. Two, a mere filing of a stay of execution application also does not operate as a stay against the execution of the orders of the court. So Parliament, having been duly served, has a duty under law to ensure that the Honorable Nyindam is no longer extended kept seats by the House as extended to members. Mr. Speaker, I'm not raising these matters whimsically because precedents will guide us. Mr. Speaker, when the Honorable Jachi Kwesi was ordered by the court that he should go through rerun of his election, members of this side at the time, mainly led by the now minority leader, spoke vociferously against the fact that the Honorable Jachi Kwesi cannot be entertained in this house. The issue was raised by Professor Kingsley Nyaku. He used to sit here. And that matter caught fire on this floor. Eventually, the Honorable Jachi Kwesi had to leave. So these matters, they are beaten path. This is a path that we have traveled. Precedent has been laid and set and laid. So nobody can edge upon this house today that the Honorable Nyindam must have a voice today. It won't happen. It won't happen. So the orders of the High Court are directed at Parliament as well as the Electoral Commission to order for a rerun of the election within 30 days. Within 30 days upon the grant of that order. Speaker, there's no contrary order from the High Court, properly constituted, nor the Court of Appeal, staying that order of the High Court. And me, as the majority chief whip of this side, we will not sit and disobey the orders of the court. So we went through the processes painfully and got a judicial pronouncement. By all means, you can hold your press conferences outside and say things against the judiciary. We won't do that. We will observe the orders of the court. If you are minded, the tournament for doing so is in the courtroom. This is the presence of Parliament and the foyers of Parliament are forum non-convenience.
Where members on this side who had won their elections through machoism and attacks were denied their votes. We know what we've all gone through. So is this nation today encouraging violence, machoism as a way to move our democracy forward? I beg to say no. And it should never come out of the mouth of a member of parliament that it should never come out of a member of parliament's mouth that he will not allow by what means. After all, in a worst case scenario, if the member remains here or decides to participate in the words of Harun Idrisu, minority leader as he then was, the decision, Mr. Speaker, I am dealing with Hansa. No, yes, no, don't worry, leader. You know what stuff I've made of. I will not get into waters that I'm unsure my ability to swim ashore. I'm very careful, extremely careful. Mr. Speaker, Honorable Harun Idrisu, minority leader, as he then was, in the matter of Jechikwesi, where a court process had been said on Parliament and on Honorable Jechikwesi, at the swearing in, argued that the filing of the injunction, Mr. Speaker, in that case it was even an injunction. In that case it was even an injunction order, an express court order, where, Mr. Speaker, there was no process that had been filed by Honorable Jechikwesi. Even so, the contention of the respected minority leader, as he then was, Honorable Harun Idrisu, was to the effect that if he decides to go against a court order, it is his sole responsibility. If in this country, as part of the jurisprudence, if you disobey a court order, it amounts to a contempt. And contempt of court is a quasi-criminal offense that you, the one who is disobeying the court, you are solely responsible. So, Mr. Speaker, this debating chamber must not metamorphose into a constitutional chamber. We should not attempt to advance a constitutional argument and make a constitutional determination where we know that there's another chamber responsible for that. Today it may be Ninda. So, Mr. Speaker, for anybody to make an argument of convenience and try to shape it in a certain form, clothe it in a certain form, to impose it on us, Mr. Speaker, we will not accept it. I therefore pray, Mr. Speaker,
how can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the vote of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court. Let me emphasize, this is a narrow exception, not a judicial blank check. The Supreme Court made abundantly clear that such power is to be exercised only when, 1, the parties have had a full and fair opportunity to address relevant issues, the evidence unequivocally supports the alternative relief, and 3, there is no element of surprise, prejudice, or procedural ambush. Now, ladies and gentlemen, none, absolutely none, of those conditions exist in this case. The High Court order is not a principled application of the Kojoba doctrine or any other known doctrine. It is a brazen abuse of it, like the judge who invoked the animal farm to remand Abronye. Consider the following facts. 1, the petition did not plead irregularities in all 152 polling stations. The petitioner did not lead evidence concerning 152 polling stations. The parties never argued about 152 polling stations. And no one, neither the respondent, nor the Electoral Commission, nor the voters of Pandai, was put on notice that the entire constituency election was at risk of annihilation. In fact, the key witness to the petitioner underscored the fact that all they needed was a rerun in some 41 polling stations. He again added that the collation was done without due notice to him. Has the judge read the CI? Has the judge listened to the Electoral Commission regarding the violent conduct of the petitioner and his followers, leading to the termination of the collation at Pandai and eventual transfer of collation to Tamale? Indeed, this is not substantial justice. This is substantial injustice, a textbook case of judicial overreach masquerading as equity. Let me be clear. We do not accept that the petitioner proved this case. But even if he did, the court found credible evidence of wrongdoing. The remedy imposed is still fundamentally flawed. It is whimsical, unlawful, and manifestly unconstitutional.
Say no. Honorable Matthew, Nindam, Parliament no onko. And I say onko penny baby ntina. It's an send I and I say Mugasi yabao. Send a majority for no woman near brea. Wama tiejina say woman ma papa ni rap parliament na ankosha adako. Onye wura hwa wama tambi bia ahwe ni tirimo. Enso de mum ntimi nyesa. Womo de woma no ena e ka keke ena politics de politics. Ye de ya no na beka. Ai. Na so me dem susu say e wo say papa no ko because he's still the MP. Na say or say oko file am panso de a onye ne ntempa so na court international. He's having just 30 days. Beka tawe ni ate no na 30 days na so. And this for so na woma ye ready a omo de womo nyanka ne ya kra no aba no ye twesa so mo vim say ye tune ne ya womo ene befa ebusia 7M TV network eso ene kai so be follow page in Facebook, subscribe, YouTube following e TikTok wo adwenkyere wo ho kwan so the to comment section say Matthew Nyinam parliament no onko and I say also pen baby tina no train for the 30 days of the rerun election. Kai said that Lumba Ayen Honsen Seminole and rather me catch her say if you had a swan, ye the moon semina ebeba abesum, Tinyamia do more channel, Nebeko so, our court biano 7M TV, ye the ba abesumo, I would see Jumedi eso. Aha, and I'm the Jumedino, ebesi, my crown.
7M TV, new vision.